rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Morning. This is the time set for oral argument in 1 CACV 23-0400, Maninda Chatha, MD et al. Versus Dharminder Marwah, MD et al. As a reminder, this hearing is being video and audio recorded. In a few days, the video will be posted to our YouTube channel. Counsel, before you begin your argument, please identify yourselves and the party you represent. Each side will have 20 minutes. If appellant's counsel would like to reserve time for rebuttal, or if the cross-appellant's counsel would like to reserve time for rebuttal on the issue raised in the cross-appeal, you are responsible for keeping track of your own time. We have read the briefs and conferenced the case. We are familiar with the issues, so there is no need to repeat what's in your briefing. And counsel, you may proceed.
May it please the court, Timothy Berg of Fenimore Craig on behalf of appellants. I'd like to reserve 5 minutes for rebuttal. The essence of the trial court's liability rulings on summary judgment is that the very success of Dr. Marwah's continued efforts to conceal the fraud he was perpetrating on his friends Drs. Chatha and Sahani immunizes him from liability because they should have disbelieved their longtime friend, partner, older brother, and mentor, and concluded that he was lying to them long before he did. Summary judgment was inappropriate here on the appellant's affirmative claims because there were genuine issues of material fact as to those claims, and summary judgment was inappropriate. But equally important, summary judgment was inappropriate on Dr. Chatha and Dr. Sahani's defenses of fraud in the inducement and failure of consideration because of the same material issues of fact, and perhaps more cleanly and easily because statutes of limitations don't bar affirmative defenses. And so the time can never run on their affirmative defense of fraud or their affirmative defense of failure of consideration. There are genuine issues of material fact throughout this case. Let's start with the simplest ones. Dr. Marwah made at least 3 material misrepresentations to his partners. He made a representation that he was being paid peanuts for his interest in the Fresenius joint venture. Peanuts in this case means $1.5 million, which is certainly not peanuts to me and perhaps not to you all. But in the context of this case, the parties treated $1.5 million as if it were peanuts, a minimum payment. 2, that he was required to withdraw as a member and manager of DKA as part of that settlement. And 3, that he was required to sell his interest in the Fresenius joint venture as part of the settlement.
Could you go to the point of being told $1.5 million? The arguments made that they were aware when they were sent an email that says your shares are valued in this amount, and it's the same formula that was used for Dr. Chatha's sale. I'm sorry, for Dr. Marwah's sale. Why didn't that put your clients on notice?
2 reasons. 1, Your Honor, it didn't tell them what the amount was. It was a vague reference to how it was noticed, and it didn't say that we valued it and came up with the same number, and that the number that Dr. Marwah sold his interest from. What Mr. Daniels' email says is that they looked at value in calculating, in representing Dr. Marwah, but equally and perhaps more importantly, even if they should have discovered it then, it doesn't bar their defenses of fraudulent inducement and failure of consideration. The judgment entered in favor of Dr. Marwah and his claims would still be inappropriate because the discovery rule starts the statute of limitations running for purposes of an affirmative claim, but it doesn't start it running for purposes of a defense. And we cite brief cases to you, including an old U.S. Supreme Court case written by Justice Roberts, I believe, not the current Justice Roberts, the original Justice Roberts, about how when someone sues you, even if you have a claim that would otherwise have run, you can raise that as a defense. And here, even assuming they should have known, and we believe there's a genuine issue of material fact for the jury. as to whether the statement made, which didn't include the amount and didn't say this is how we calculated Dr. Marwah's interest, but simply we used value in calculating his interest, was sufficient to put them on notice and start the statute running on their claim.
So they're using it as an affirmative defense. They could, let's say they were told I only received peanuts for the sale, 1.5 million, and then the next day they learned that he actually received 10 million. Can they wait 6 years and just stop making payments on a contract and saying, well, we really didn't, is there any limit to using it as an affirmative? They've stopped payments.
The limit to using it as an affirmative defense is the statute of limitations on the claim it's a defense to. I'll give you an example. You defraud me and I breach a contract with you. My affirmative fraud claim against you, the 3-year statute runs. Assuming it's a written contract, you have a 6-year statute of limitations to sue me. My affirmative defense is still good for those other 3 years if you sue me. I can't come and get money from you based on the fraud, but I can prevent you from getting money from me based on your fraud because it's an affirmative defense. The purpose of the statute of limitations is to keep people from suing on stale claims. And if the statutes run, then affirmative claims would be barred. And we take the position there's a genuine issue of material fact here that would preclude summary judgment on that issue. But once you even pass that, it does still operate as a defense to the claim that, to the breach of contract claim. If you fraudulently induce me to enter into a contract, I'm entitled to defend against a suit by you even though the statutes run on my affirmative claim. That I think it's clearly the law, and it's certainly our position today. The email that you were talking about simply says that it's how Dr. Marwah's interest was acquired. It doesn't say that it was a specific value. It doesn't say what was done. We don't think that's sufficient. We think it's a jury question. I mean, can a jury conclude that Dr. Chatha and Sahani, sorry, I'm going to do that once or twice, should have begun discovery? Yes. Could a jury conclude they shouldn't have? Yes. It's a material issue of fact. As this court has repeatedly held, generally questions of when the discovery rule starts to run are questions for a jury because it's a question of what reasonable people, of either what people knew, which is clearly a fact question, or what reasonable people would have done, which is also clearly a fact question. The jury is the one that gets to decide if it's reasonable or not for the appellants to have read that email from Mr. Daniels and not concluded that they needed to investigate what Dr. Sahani's interest had sold for. The other point that's important, though, is that that's only one of the 3 fraudulent misrepresentations that Dr. Marwah made. He also told Drs. Chatha and Sahani that he had to sell his interest in the Fresenius joint venture as a condition of the settlement, and that he had to resign from DKA as a condition of the settlement. Neither of those were true, or at least there's a genuine issue of material fact as to whether they were true. And those fraudulent representations separately would support a claim for fraud against Dr. Marwah and support a defense of fraud against Dr. Marwah's affirmative breach of contract. Dr. Marwah, all 3 of the breach of contract claims are also a breach of contract.
Wasn't that part of the same argument, though, that I had to sell at a reduced price? If he said, I sold it and made $15 million, it was a condition of the sale, would that have been enough? If he'd actually told them the exact amount that he received, I was forced to do this, would they have still gone? It
would still be, because they promised him additional things, because he said he had to resign, he had to sell his joint venture interest, and he had to resign from the partnership, those separate material misrepresentations would also be actionable, and they'd have to have a reason to discover those, as well as the price. If you assume for a moment, and I don't concede at all, that Mr. Daniels' email was sufficient to create a duty to investigate, it was as to the price, not as to the question of whether Dr. Marwah had to resign from DKA and whether he had to sell his interest in Fresenius. Those are separate material misrepresentations that support a fraud claim by my client and certainly support a fraud defense.
A moment ago you said that when a cause of action accrues and the discovery rule and so forth, those, what a reasonable person would have done, those are issues of fact for the jury, but that's not what the Coronado court held. What's the distinction?
Well, first of all, in Coronado, the facts are materially different. The plaintiffs were essentially told by the lawyer they had been defrauded. They believed they had been defrauded, and they still waited to file their lawsuit. In this case, no one had told Chatha and Sahani they had been defrauded in 2013, 2014, 2015, 2016. And they didn't believe they'd been defrauded. Why? Because the person they were dealing with was their mentor, their friend, their big brother. Essentially, it would be like saying to someone who worked in a law firm, the senior partner who's brought you along all this time, who's trained you, who's supported you, who's helped you get where you are, you ought to be suspicious of him. And of course you wouldn't be, just like you all wouldn't be suspicious of each other. There are relationships in life that create a bond of trust. And this was that kind of relationship, Judge Kiley. I'm sorry. Actually, it was Judge Catani's question. I apologize, Judge Catani.
No.
It seems to me that this is a case that should have gone to the jury. And I cannot find the name of the case in my outline. But there is, in fact, a Court of Appeals opinion that Judge Catani wrote that I think is perfectly on point. Let me find it. Coulter versus Grant Thornton is the case I'm thinking of. In that case, similar situation, similar questions of whether or not someone should have discovered, in that case, accounting malpractice rather than fraud, and other similar claims. And what this court held was that that there's a genuine issue of material fact there. And I think it's almost always going to be a genuine issue of material fact. Is it possible that you would have a situation where there isn't one? In 2014, Dr. Marwah had said to Dr. Chatha and Sahani, I lied to you. I didn't sell it for $1.5 million. I sold it for $9 million. Maybe there's no jury question there anymore. But I think short of something that obvious, that clearly they know or should know that they've been lied to, it's a jury question. That's why we have juries. That's why we have trials, to resolve questions. You have here conflicting evidence. Dr. Marwah says he never says some of the things Dr. Chatha and Sahani says he said. That's for a jury to decide whether Dr. Marwah is credible, Dr. Chatha is credible, Ms. Price is credible, Mr. Daniels is credible, Dr. Sahani is credible. Those are jury issues. The trial court here jumped over the point and decided he believed Dr. Marwah and granted summary judgment, and that was plainly inappropriate. The other argument plaintiffs make that I want to cover briefly is that somehow Dr. Chatha and Dr. Sahani are barred by what Mr. Daniels knew. If you look at the Restatement 3rd Governing Orders 28.1, it's clear that if Mr. Daniels was representing Dr. Marwah in a separate representation, the knowledge he gains cannot be imputed to Dr. Chatha and Dr. Sahani. And indeed, Rule 1.6 of the Arizona Rules of Professional Conduct would preclude him from telling anything about his separate representation of Dr. Marwah to Dr. Chatha and Sahani. That's a very broad, very restrictive rule. I'm occasionally chided by one of my partners and told I can't send things that are matters of public record to other people if my client doesn't approve it. Whether it goes that broadly or not, I don't know. But it certainly would cover the information that Mr. Daniels knew as a result of his separate representation of Dr. Marwah. Is there a genuine issue of material fact as to whether it was a separate representation? Absolutely there is. Mr. Daniels testified it's a separate representation. Ms. Price and Mr. Goddard testified that Dr. Marwah's sale of his interest in Fresenius and resignation from DKA were not part of the settlement. They weren't conditions of settlement. What Mr. Daniels was doing was separately representing Dr. Marwah in the sale and resignation. And therefore, he couldn't tell Dr. Chatha said, it doesn't matter whether or not there's a confidentiality provision in the agreement, although there is. It matters, and under Rule 1.6, he simply couldn't do that because it was a separate representation. If the panel has no other questions, I'll save my last 6 minutes for rebuttal. Thank you.
Thank you.
Good morning, Your Honors, and may it please the Court, Robert Schaefer on behalf of the appellees and cross-appellants. Judge Morton's summary judgment ruling on liability should be affirmed because the record indisputably establishes that Drs. Chatha and Sahani had actual knowledge of the falsity of the representations. They had actual knowledge because their lawyer had actual knowledge, and their lawyer's actual knowledge is imputed to them.
But isn't that a separate, are you saying it's all part of the same transaction, or at the point that Mr. Daniels is representing him in this sale, does he know that your client is going to make misrepresentations as to the amount that's being received? At what point does Mr. Daniels have an obligation to share that information, or can he share that information with the other doctors?
So we are assuming for purposes of today and for summary judgment that Dr. Marwah made the misrepresentations that are alleged. We're not conceding that he made them, but we're assuming that he made them.
We absolutely must assume that.
We must assume. So the question is, was there a duty on Daniel's part to disclose the amount that Dr. Marwah was receiving in the sale, which was a express term of the settlement agreement? The aggregate settlement rule says that the lawyer who represents joint clients, multiple clients, has an absolute unwaivable duty to disclose, even if it's confidential. Even 1.6 applies. The lawyer has to go to his client and get that client's consent to disclose. But it's not optional.
Does that mean that that knowledge must be imputed whether or not the information was actually imparted to the client?
Absolutely. Absolutely. That's the purpose of the aggregate settlement rule, is to protect clients from being accused later that they've misled their co-client about the nature of the settlement. It's a very clean rule.
When it's separate, it seems like it's a separate transaction when there's a confidentiality requirement that says you can't disclose the amount that you received. How does that necessarily become part of the overall?
That confidentiality provision didn't need to be there. It was a proposal from Fresenius. Okay, Fresenius sent a document that had a proposed agreement in it. Dr. Marwah should have been told, we need to disclose this to your partners, and therefore we need to negotiate an exception to this confidentiality agreement. And the ABA ethics opinions on Rule 1.8, which is just the ethical parallel rule to the aggregate settlement rule in the fiduciary context, makes absolutely clear that the lawyer simply does not have the ability to not disclose it. He must have his client's consent. And it recommends that the lawyer get the client's consent at the outset of the representation in the engagement letter.
So the court is entitled to find, as a matter of law, that information was in fact shared with the client because it is required to be shared.
Absolutely.
Regardless of whether it was or not.
Absolutely. That's 5.03 of the restatement. And it's the same as the restatement of law governing lawyers, Section 28. Section 28 says that the lawyer's knowledge is imputed to the client when the lawyer learns information that's material to the representation during the representation and it's related to the representation.
But why is it material at the point before the misrepresentation? The misrepresentation is made much later, presumably, that just I'm going to flat out lie and say I received 1.5 million when I received whatever the amount was. Why does that put the lawyer on notice that there's been a misrepresentation, or that amount was material to something? It doesn't become material until a misrepresentation is made.
Unfortunately, that's not the case, because the aggregate settlement rule makes it material. It doesn't have anything to do with actual misrepresentations. It has to do, it's a prophylactic rule. It says lawyers must disclose this so their clients can't accuse each other of fraud. Lawyers must disclose this to protect their clients from each other, from clients coming back later and saying, you know what, I didn't know you were actually getting that in the settlement. I wouldn't have agreed to this if I had known that. Has nothing to do with actual misrepresentations.
That's the purpose of the rule. But you're saying we have to conclusively presume that the lawyer complied with the rule, whether or not he did.
No, what 5.03 says is that knowledge is imputed unless the lawyer has a superior duty to keep it confidential. The aggregate settlement rule says a lawyer does not have a superior duty to keep aggregate settlement terms confidential. I mean, that's the bottom line. It's as simple as that. But even if we're looking at the actual misrepresentations, okay, in that case, Dr. Chatha and Sahani and ARI were on one side of the transaction. Dr. Marwah and M&M were on the other side of a transaction. This is the consulting agreement. Jack Daniels drafted the agreement on behalf of both parties. Therefore, the lawyers had duties of disclosure to both parties. That's the Manley versus Tycourt title case. When a dual agent represents two principals, they're obligated to disclose material information to both parties.
I'm still struggling with why it's necessarily material. If the clients come together and say we want to agree on a consulting agreement, this is what we're doing. Why does the lawyer necessarily know that there's been a misrepresentation?
The lawyer may not know there's been a misrepresentation, but the lawyer knows that their clients are transacting based on the fact that Marwah sold his interest, okay? So Marwah sold his interest. Now, Daniels told Marwah he couldn't tell them how much he sold for. So Daniels knows that these parties are entering into this side deal, and Marwah has not, or at least he should not have told them the amount, according to Daniels, and Dr. Marwah says he didn't, and the others say, well, he told us 1.5 million. We're accepting that for purposes of today. But the lawyer in that context that knows these parties are entering into a transaction and purports to act as a scrivener has a duty to disclose before he can act as a scrivener. He has to make sure the clients are fully aware of all material facts. And it's not material facts that the lawyer knows are material. It's material facts that are objectively material to the client. The lawyer must anticipate what the client's interests are and act to protect
but
the client's
interests. The lawyer must anticipate that if the lawyer tells Mr. Marwah that he can't disclose the amount, that it's confidential, the lawyer has to anticipate that Marwah is not going to, or is not going to lie about it down the road?
See, it's a chicken and egg problem because there were so many mistakes that the lawyers made. I mean, they should not have told Dr. Marwah that he was obligated to keep this amount confidential. They should have gone to him and said, we have an obligation as the lawyer for all four clients to make sure all four clients understand what the terms of the settlement are. And the settlement agreement, and there's no dispute on this, Your Honor, that it expressly states that the sale to FMC of Marwah's interest is a condition of the settlement. It expressly states that. So, I mean, we understand that Susan Price has said that it wasn't, she didn't make it a condition. But she never says she spoke to Dr. Marwah. Dr. Marwah dealt with Fresenius. So maybe...
And you're saying that's not a fact issue when you have the affidavit, her affidavit, that doesn't create...
Well, that's a fact issue as to whether it was a condition or not, but that's not a material issue. That's not a material fact. And the reason why it's not material is because the lawyers had an absolute duty to disclose the terms of the settlement. So we assume that they did that. That's what the law says. We must assume, we presume that the lawyer complied with the duty and passed that information along. Therefore, Drs. Chatha and Sahani had actual knowledge of the sale price. Because they had actual knowledge of the sale price, they could not have relied on a misrepresentation about the sale price. And under the Silva case from 1933, Justice Lockwood, again, settled law, this is the same law that's been in existence for over 100 years, is that once you're on notice of the possibility of fraud, you're under a duty to inquire, and you're constructively you're deemed to have constructive knowledge.
Daniels knows the sale price. The fraud hasn't been committed. So you're not on, I'm still struggling with how the plaintiffs in this case are on notice that a fraud's been committed just because Daniels knows the purchase price. The fraud doesn't happen until later on when your client says something different. And then now we have to go back and say the plaintiffs should have known that because their lawyer knew the purchase price. But the fraud hadn't been committed. They can't be on notice of a fraud based on the...
No, what gives them notice of the fraud is the fact that they must be deemed to have knowledge of the truth. If you have knowledge of the truth and someone tells you something and you know it's not true, you don't have the right to rely on it. And you have a duty to inquire, not only as to that particular alleged misrepresentation, but as to every related misrepresentation.
That would make sense to me if they're drafting the agreement at the same time, the subsequent agreements, the consulting agreements, whatever the agreements are called, after the representation that I was only paid peanuts. But that doesn't happen then. It's not contemporaneous.
No, it is contemporaneous. The agreement is dated in February, but the oral agreement that preceded it, which was Dr. Marwah agreed that he would agree to the settlement, which he wasn't obligated to do, and which was a very bad deal for him. Okay? It was a detriment to him to agree to sell his interest. Okay? There's no dispute about that. And
you're saying there's no dispute if he says I only got 1.5 million, that seems like it's a big detriment compared to if I got 10 million from it.
The detriment was in selling an asset that is paying him $2 million a year in income.
But
he got $9 million.
You agree that it's a bigger detriment if you're forced to sell it below what it's actually worth, that they only receive a small amount.
My point was to respond to the argument that there was a lack of consideration. Whether it's a bigger detriment or a smaller detriment is irrelevant to that. It's a detriment. He wasn't obligated to agree to this. This was, in a sense, a unilateral contract. The agreement was, if you, Dr. Marwah, agree to this settlement, we will agree to pay you this money. So it was a promise in exchange for performance. Dr. Marwah performed. The other people then have a binding promise. They say they can get out of that promise because Dr. Marwah misled them about the sale price. But they knew the truth. They must, as a matter of law, if we're right about the aggregate settlement rule, they must be deemed to have known the truth. And therefore, they cannot rely on the misrepresentation about the sale price. They were also on inquiry notice under the Silva case as to the other alleged misrepresentations. And we know that eventually what the plaintiffs did is they hired a law firm. The law firm investigated, took depositions, discovered these things. Those same things would have happened if they had brought this lawsuit at the time of the settlement. Same thing would have happened if they had brought the lawsuit after the May meeting. The lawyers would have taken depositions. Dr. Marwah waived confidentiality. He testified freely to the amount he had received once he was being deposed. Even though Jack Daniels told him he couldn't, he waived it. Fresenius hasn't sued him for breach of confidentiality.
So you're saying even if Dr. Marwah, if a jury were to conclude or someone were to conclude that he made an affirmative misrepresentation, the other party was not entitled to rely on that because they were conclusively presumed to have knowledge of the truth because their lawyer knew the truth, and we must conclusively presume that the lawyer complied with his obligations.
That's the law.
Regardless of what the facts are.
Well, the facts are we have a settlement agreement of 4 joint clients. Those are the facts.
Okay, but you're saying we look at the lawyer's code of ethics and presume that the lawyer did everything he's supposed to without regard to what actually happened in the conversation.
Absolutely. That's the law. 5.03 of the restatement, which was adopted by the Arizona Supreme Court. It's been applied to determine how imputation applies, and you just follow it. You presume that the knowledge has been disclosed if there is a duty to disclose.
Let me create a little more sinister. I'm not saying this happened, but let's say Dr. Marwah hears, okay, Mr. Daniel says this information can't be disclosed. Now that I know that, well, this just creates license for me to make misrepresentations. Now that I know that he's not going to tell anyone, I'm going to go and lie to people, and I'm going to just fabricate to induce them to give me a contract.
There's
that works
no
then?
case that I've found, and there's no restatement provision that I've found that says that fraud isn't an exception to imputation. Imputation exists to put an incentive on the party that's best able to control the agent. Okay? That's the purpose of imputation. And if the lawyers made a mistake, Dr. Marwah should not be the one who pays the consequences of that. This rule, the aggregate settlement rule, exists to protect clients. And they did not protect their client. They misled their client. And even if their client is assumed to have taken advantage of this, it's not a defense
And so
to
in
imputation.
your view then, I'm guessing, is simply that the lawyer's obligation, it doesn't have to figure out what may or may not be relevant information that has to be disclosed, depending on factors that occur down the road.
No, it's just if it's part of the
lawyer.
settlement. If it's part of the settlement, if it's consideration that a client is receiving in the settlement, it has to be disclosed to all the clients. Dr. Marwah's sale and the amount he was receiving was part of the settlement. That's what the settlement says. Now, they can say that it wasn't really part of the settlement and that these doctors could have achieved this settlement without Dr. Marwah's sale. But there's no evidence that Dr. Marwah spoke to Susan Price. There's no evidence that he had knowledge.
An affidavit, that seems like that's evidence that
Well,
it wasn't.
but her affidavit, you have to actually parse the declaration and see what she says. She doesn't say she spoke with Dr. Marwah. She says she was privy to the negotiations. Well, that's vague. What does that mean? Is she saying she told Brian Gallagher at FMC that AKDHC would agree to this even if Dr. Marwah didn't sell? She doesn't say that. She doesn't say she spoke to Dr. Marwah. She says she was privy to the negotiations. But it's an immaterial dispute because it doesn't matter, because they were on notice from the very beginning that there was the possibility of fraud. They had actual knowledge of the possibility of fraud. That created a duty to inquire. And then we look at what would they have discovered if they had inquired. Well, we know what they discovered when they inquired. And the same thing would have happened if they had acquired earlier.
And is Mr. Berg correct that limitation statutes don't apply to affirmative defenses?
Sure, yes. So when we come to the May email, the question there is, did that put them on inquiry notice? Because if it did, it's the same analysis. You then look at what they would have discovered if they had done a diligent investigation. And it's not a timeliness issue. It doesn't trigger an accrual of a limitations period for a defense. What it does is it puts them on constructive notice of the fraud. Once you're on actual or constructive notice of the fraud and you affirm the contract, you waive your equitable rescission defense. So it's not a question of statute of limitations. It's a question of whether they waived their equitable rescission defense by paying on the contract for years after they had actual or constructive knowledge.
That's not a jury question.
How could a jury say that paying on a contract does not affirm the contract?
So you're saying as a matter of law, the
Yes.
court can decide that what they did amounted to affirming the contract and thereby waiving their defenses?
Yes.
And under your theory, the email suggesting that Marwah received a price based on the same multiplier or whatever their interests were valued, that's irrelevant to anything. If that's you're saying their notice was when the original Daniel's knowledge up
Yes.
front. So so
Yeah,
you're not relying at all on the email.
No, we're saying you could use either one. Doesn't matter which one you use.
If you're using the email, you're saying that email is specific enough to let them know that he did not receive it, that it's contrary to what he expressly told them. He told them
Well,
1.5.
the question isn't whether it gave them the facts of how much Marwah made. The question is whether it gave them enough to know that they needed to follow up. And obviously, they should have picked up the phone and said, Dan, you know how much Marwah was paid? Yeah, I know how much Marwah was paid. Well, you said it was based on a multiple of earnings. You know the multiple that was used? Yeah, I know the multiple that was used. I mean, is there any reason why he didn't pick up the phone and make that call. He had just been told in a term sheet, a signed term sheet, that Sahani and Chatha signed, that this was going to be a sale at fair market value. Then they claim Marwah misled them and told them he's getting less than fair market value. He's only getting 1.5. Then they see that their lawyer values their interest on a fair market value at 9.75 because that's what DAR's interest was acquired for.
This is 2 years later, is that?
No, it's 3 months after the settlement, 4 months after the
3
settlement.
months after is when their interests are valued.
Yes.
Okay.
Yes. So.
Thank you, Counsel. Your time's up.
Thank you.
May it please the court. The issue here, buried under all of this, is what knowledge that Mr. Daniels had is imputed to Drs. Chatha and Sahani. I'm reading comment B from section 28.1 of the restatement. A client is not charged with a lawyer's knowledge concerning a transaction in which the lawyer does not represent the client, if there is a genuine issue of material fact here as to whether Mr. Daniels was representing only Dr. Marwah and not Drs. Chatha and Sahani in negotiating the sale of Dr. Marwah's interest in the Fresenius joint venture and his withdrawal from DKA, under the restatement, that knowledge is not imputed to Drs. Chatha and Sahani, and the statute of limitations cannot begin run and fraud cannot be defended based on what Mr. Daniels knew about the price. But equally important, Mr. Schaefer tells you that, well, Mr. Daniels knew about the purchase price, and so you should impute that knowledge to the doctors. What he doesn't tell you is that there is nothing in the record that reflects that Mr. Daniels was told by Dr. Marwah. In fact, it reflects the opposite. Mr. Daniels did not know that the settlement agreement did not require the sale of Dr. Marwah's interest in Fresenius or interest in DKA. Those are separate material misrepresentations. And if Mr. Daniels never knew them, the knowledge can't be imputed to Drs. Chatha and Sahani. The statute cannot run on them for an affirmative claim, and certainly you cannot bar a defense of fraud or failure of consideration based on knowledge that neither Mr. Daniels nor Drs. Chatha or Sahani had. Again, the point here is that once Dr. Marwah counterclaimed to enforce the agreements, the issue of the discovery rule falls away because the issue of the statute of limitations doesn't apply anymore, and the Drs. Chatha and Sahani are entitled to raise fraud as a defense to those claims. We contend they were also able to continue with their affirmative claims because it was a genuine issue of material fact. There is a genuine issue of material fact about whether or not Mr. Daniels was separately representing Drs. Chatha and Sahani in the settlement agreement and Dr. Marwah in the sale. Mr. Daniels testified so. Ms. Price testified it wasn't a condition. The sale and withdrawal wasn't a condition. Mr. Gauger agreed with that. That is enough to create a genuine issue of material fact here. This case ought to be, what the court should do is vacate the judgment, remand this for a trial on the issues, on both the claims and the counterclaims, but certainly on the counterclaims because the affirmative defense hasn't run. If the court has no other questions, I have nothing further to add. Thank you very much.
Thank you. We will take this matter under advisement and issue our decision in due course. We're adjourned.